Good afternoon, courtroom two. May I go ahead and give my announcement while we await everyone else to join us?
Yes. Yes,
Very
John.
good. Thank you. Good afternoon. Good afternoon, ladies and gentlemen. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video. You have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present for these proceedings. We are offering you the assistance of a public defender this afternoon or a conflict attorney if you choose to utilize their service. Where would you like to start first, courtroom two?
Your Honor, we could start with position number 4, Ms. Carpenter.
Who's representing Ms. Carpenter?
Good afternoon, Your Honor. Sarah Armstrong on behalf of the defendant.
Hi, Ms. Armstrong. Good afternoon. Good to see you.
As well.
Thank you. And who's presenting for the state?
Attorney Armstrong.
I believe it's ASG Pamela Westman, Judge.
I'm sorry,
Okay.
what's the name? I didn't catch it.
Good afternoon, Ms. Westman. This is position number 4, Ms. Carpenter.
Okay,
Sorry.
thank you.
That-
Apologies, Your Honor.
No, you're fine. We're a bit early. Good afternoon, Ms. Carpenter. I'm Judge Eric Morrow. You've been charged in case 25 CR 002097C with battery family violence. Is Mr. Howard on? Ms. Westman, do you have the arrest? It's my understanding it's the third arrest.
That's my understanding as well, Your Honor, for theft, fleeing a police officer. There was a diversion program there, out of Minnesota, a felony forgery check arrest in 2018, and in 2022, there was a battery family violence terroristic threats was amended, and the battery got a First Offender Act, and the aggravated assault was null prost.
Thank you, Ms. Westman.
You're welcome. Would you like me to go through the case or?
Yes, please. You can
Okay,
proceed.
thank you. Okay, on April 21st at 9:25 Canterbury Road, Atlanta, an officer responded to a fight in progress. The victim being Mr. Karika Culberson, stated that he was arguing with that he and the defendant were arguing when the defendant grabbed him by his hair and dragged him into a wall. The victim had visible bleeding, and Mr. Culberson also had scratches on his forehead. However, he did refuse medical treatment. We spoke to the victim today. The victim and the defendant are in a relationship, and they live together at the location of the incident. They do not share children. The victim did confirm the events in the warrant and stated that this is the first time this has happened. Victim stated that he is not in fear of the defendant, but he does not want contact and does not want her to return to the residence. He would like the defendant to get a one-time law enforcement escort to retrieve her belongings. And the defendant is going to try and be on the Zoom. So that's what I have for that. We would like a $1,000 surety bond. No further contact with the victim, as well as a stay away from the home that is at 925 Canterbury Road. Give me 1 second. Sorry, I just had something. And a family violence intervention program. And at this time, we would sound for the defendant, Mr. Culberson.
Mr. Culberson, I see you on the line. If you would like to address the court, now is your opportunity. If so, you'll need to unmute yourself, activate your camera, and I will have to swear you in if you choose to address the court.
Yes.
Yes, good afternoon. If you can raise your right hand for me, please. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down, sir. What would you like to tell the court?
All right. So what I would like to tell the court is, first and foremost, I do apologize for, even this situation. Like earlier stated, we are in a relationship. You have your ups, you have your downs, right? And when I had originally called you guys, it was on the front. We've had situations where we've had law enforcement called, right? It wasn't anything violent or domestic, anything like that. But the situation is kind of hard, being that we live together. There's kind of like a power dynamic when it comes to the household, right? And just kind of living and coexisting together, right? So one thing that I do feel like was not mentioned in this whole situation is yesterday I was under the influence, right? So when I say of alcohol within my own home, right? So I'm saying all that to say that the situation that had happened with my forehead and me hitting the wall, it was so at the time we was chasing after each other. Well, I was chasing her trying to get into the house, right? Because had fear that she was going to lock the door, right? So if you look at the apartment space, like when you make that turn, it is pretty easy to slip, pretty easy to fall, right? And I do feel like the testament that I gave to law enforcement at that time, it could be a little foggy on that front, just being full transparent with the court. Because she was running. I'm not the smallest guy in the world, so I don't think that she was running for her life. But I do think that, she was trying to get in the house, right, in the home where she feels comfortable. So, to me, all I seen was or felt was my face plant into the wall, right? But just based off the conversations, I do feel like there is a small chance that maybe she didn't have any malicious intent on actually causing harm to me, but more so getting out of the way of harm with not knowing the expectations of what could possibly go down. So I don't feel like that's being properly, because like with the courts, it's always yes, no, right? My biggest thing for calling law enforcement yesterday was getting her out of my house, getting her out of the house. That was the main thing for calling yesterday. But at the end of the day, like I said, this isn't our first scenario where the law enforcement has been called, and by law, she lives there, so I can't legally get her out. But fumes were high yesterday, and at the end of the day, that's the approach that we had to, well, that I had to. So I just say
Okay.
that, Your Honor.
Mr.
Thank you, Mr.
Culbertson,
Cole.
if I can ask him a question? Have
Yes,
you
ma'am.
received, thank you, Your Honor. Have you received any communication from the defendant since her arrest?
Have I received any communication with her?
Spoken to her, emailed with her, any type of communication at all with the defendant since she was arrested?
No, no, I have not spoken with her. I have spoken with her family. So, and actually, yeah, she did call me last night. She called me just to basically try to find like a bondsman or whatever. And I was already in accordance with that, right? So I was already looking for bondsmen, and I was also speaking with her mother and her father about trying to get her out of this situation. Because once things kind of simmered down, um, you know, obviously trying to look for a resolve.
Anything
Okay.
further, Ms. Weissman?
No, that's all, Your Honor. Thank you.
Thank you. Thank you for being here, Mr. Culbertson.
Yes.
Ms. Armstrong?
Thank you, Judge. We would ask for, if possible, the laws have changed, so if I make an argument that's improper, I appreciate your patience with me, but if pretrial, the signature bond through pretrial services would be available for Ms. Carpenter, we of course would ask for that. She is in the process of applying for jobs. Just out of respect for her, I don't want to say on the record the kind of jobs, but they do require higher level skills. I could say that with confidence to the court. We have no opposition to the no contact order. Ms. Carpenter can live with her sister, who is in the greater Metro Atlanta area. So I'd advise Ms. Carpenter she would need to update her address with the court upon release. And I would just ask Your Honor to give the proper weight to the statement that the alleged victim has provided to the court. And finally, just for the purpose of the prior conviction, it is under first offender. So we'd ask the court not to consider that a conviction since it's under first offender. Thank you.
Okay, it will be a $3,000 signature bond through pretrial level 2. No further contact with Mr. Culbertson. Stay away from the Canterbury Road address. She can go back to that address on one occasion with law enforcement to retrieve any belongings. No drugs, alcohol, weapons while out on bond. Good luck to you, Ms. Carpenter. You as well, Mr. Culbertson.
Thank you.
You're welcome. Who do we have next?
Position number 6, Mr. Doucette. Somebody got to help him. And Yana, we would need a Spanish interpreter today.
Okay. Let's see, Ms. Grace, have we, good afternoon, Ms. Grace. Have we requested a Spanish interpreter?
No, I jump on it right now, Judge.
I appreciate it. Thank you.
I don't mean to cut anybody off. Was that for Mr. Doucette or somebody else?
Oh, someone else.
Okay.
Someone else.
All right, thank you.
Good afternoon, Mr. Doucette. You have been charged in case 25 CR 002091F with 2 counts of battery family violence. Mr. Howard, good afternoon. Is there a history?
Hey, fifth, got an open battery, 2 counts, cruelty in the third. It's 24 PI 007 611. 2024 battery DV dismissed. 2023 battery DV cruelty to children PTI, then it was dismissed.
Thank you. Who's presenting for the state? Okay, anyone from the state want to present?
You said position 6. This is Doucette, right?
That's correct, yes.
I believe that's Ms. Westman as well.
Westman for the state. Thank you. I apologize. I was
Thank you.
having computer issues. My apologies.
Okay, no worries.
Okay. In this case, give me 1 second. Computer's still acting up. Okay, I apologize. Okay, April 19th at 4001 Lakemont Drive in College Park, an officer responded to a call that the victim, Miss Carolyn Minshew, made. She had run from the apartment and was in the neighbor's apartment when she made the phone call to police. The officer reports that what he discovers is that the defendant and the victim were having an argument. The defendant used his fingers to scratch Miss Carolyn Minshew, the victim, her face, causing swelling to her right eye, visible red welts, and scratches to her face and neck. The victim said she is a chef and asked the defendant to help her mark some knives up with tape so she could know if another chef took them. She said the defendant got angry because she wouldn't mark the knives the way that he wanted to and pushed her after she told him she didn't want his help anymore. She said she was trying to calm the defendant down while she was holding a knife, and she accidentally touched his arm. The victim, Miss Minshew, said the defendant then tried to kiss her, but she refused, so he got angry and scratched her face, causing her face and eyes injury. The officers say that the defendant was bleeding from his arm. They did see that. And that he said he was trying to help. She said he wasn't doing it right. So she bit his arm and sliced his arm as he reached for a knife to wrap it. The defendant also claims he was trying to leave and she grabbed him by the neck and said she was going to kill him. And that incident happened at the time when she was reaching out, when the victim's face to defend himself, sorry. He does have welts on his neck and a bite mark bruise on his right arm, according to officers. Both were arrested and they were both treated on the scene. They refused transport. The victim and the defendant, this is not the first time that police have been called. In fact, they're both in custody and we don't know at this point where the children are. The the case against the victim is being dismissed today by the DA. The record shows she's been victimized multiple times. The defendant is out on bond, and part of the conditions in that bond of aggravated battery from October 2024 say that the defendant is prohibited from living in the place with his wife and children where he was arrested. So he is violating bond conditions in the October 24 aggravated battery that is still open. They have 2 young children. One is born in June of 2023. One is born in September of 24. So about 6-7 months old. In the past case, well, I won't get into that, but the arrests for this gentleman, there was a domestic in Washington State that was dismissed, and as well as this one right now, and then that's open. And then there's a July 2023 battery, family violence, and cruelty to children that was a pretrial diversion that's still open. At this point, based on the blatant disregard for the prior bond, the 2 young children that are being subjected to this kind of violence, we don't know where they are right now, and all of the facts of this case and the prior violence, we're going to ask for a $6,000 cash bond, no further contact with the victim, stay away from the home, the workplace, no alcohol, drugs, or weapons, a family violence intervention program. And at this time, we would sound for the victim, if she can, I'm not sure she could, Carolyn Minshew.
Okay. Ms. Minshew is with us and wishes to address the court. Now is your opportunity. Doesn't appear so. Ms. Armstrong?
Thank you, Judge. I'm going to thank you in advance for indulging me in providing the court with some context in this case. As you may have heard Courtroom 2 say, Mr. Doucette's going to need some help. That is because he is legally blind. He was legally blinded in January of this year by his roommate at the Fulton County Jail when he was in custody on, according to the state, a charge that involved Ms. Minshew. Upon his release, he has received whatever care has been able to be provided to him to restore the little sight he has left. He's 90% in one eye, 75 in the other. And with all due respect, the allegation that he was helping with knives, given his lack of vision, I'm going to just stop it there and, of course, leave that to the court's discretion. This is his apartment. On the order that was set by Judge Wolf today, she is to stay away from the 4001 location. This is his apartment. It has, I can advise the court that my client reports that it has been furnished or altered to accommodate his blindness. So it asks that he be able to stay in the apartment that's been designed to allow him to function.
We're not requesting a stay away. We understand that that's where he lives.
Then I misunderstood. Thank you for clarifying. It's my understanding that the children are with a caretaker, maybe a grandparent, just putting that on the record. We were asking for what the lowest bond possible in this case. I'm not even sure if Mr. Doucette's going to be able to complete an FFIP class just given his blindness. I defer to the court, and I'm happy to provide more information as needed.
And Your Honor, just for clarification purposes, Anna Allen for the state, the facts in the police report are provided by the defendant. So Ms. Armstrong, while letting the court know that this defendant received an injury when he was in Fulton County Jail last time for an aggravated battery on the same victim, her claim is that it's nuts that the allegation in this case is that he used a knife or was helping her with her knives. That information actually comes from him. He's not completely blind. He's under an order of the court that requires he have no violent contact with this woman or their children. It is a very specific order and detailed. And the only reason he actually got that modification allowing him to get out was because of the injury he received in jail. So it's his facts and his contention that when he was trying to help his wife with putting tape and labeling her knives with her name on it, he was assaulted by her. The fact of the matter is this defendant has prior documented violent actions against the same victim and is not supposed to be in contact with her in a violent way. We're not alleging that she needs to stay away from that location. In fact, the cross defendant or victim in this case actually filed a notice with the court in the open case that she was moving to Douglas County. So she shouldn't be there and living together because the bond order specifically says they shouldn't be cohabitating. So on multiple levels, there's a complete disregard for the orders of the court, for the safety of these children, and for the continued normalcy, quiet, and not volatile environment. Our office has let DFACs know that they need to be involved if they aren't already and provided documentation related to these cases. There's clearly an issue going on here that small children should not be exposed to. Not all victims respond by cowering in a corner. Some people fight back. And if you look at the case documents from the open case in Superior Court, the victim also battered. All you have to do is look her up in jailings right now. You'll see both of her eyes are completely blackened. She fights back. She reported to police in October that she had to fight back 3 separate times in one evening before they arrested this gentleman. So the state's not confused that sometimes both people can get arrested because cops often don't know what to do. And the best thing to do is to separate everyone. But my understanding is the DA is dismissing their case today because it's clear based on the record that she has constantly been victimized by this gentleman and he's now in violation of a bond. She fled to another location and called police, and there's a safety issue, Your Honor. Thank you.
Okay. And just so I am clear, I believe that I was told earlier that for the aggravated battery, that he had to stay away from this Lakemont Drive address. Is that the case or not?
No, Your Honor, they're to have no violent contact and they're not to cohabitate. It was placed on the record in that case that the home there, this address, was facilitated and made so that he could be there after he was injured in the jail and she was moving to Douglas County. So the reality is that there's a condition on him prohibiting him from having violent contact with her and from cohabitating with her. And the incident in front of you happened at that same location where he lives, where there's clearly violence happening, and that's a violation of the bond. We're not asking that he be ordered to stay away from his home, but there clearly needs to be no contact.
Okay. As such, it will be $1,000 good bond per charge, makes for a total of a $2,000 good bond. No further contact with Ms. Minshew. No drugs, alcohol, weapons while out on bond. I'm going to let DFACs handle the situation with the children. As such, he is to abide by any DFACs orders or any Superior Court orders in regards to visitation. Anything further on this, Ms. Armstrong, Ms. Westman?
Just very briefly, I apologize, just because I want to make sure that the court did not think I was attempting to make any misrepresentations. As I read the police report, it was Ms. Minshew who reported the interaction with the knives. So again, I just wanted to clarify that out of candor to the court, that I did not want to misrepresent anything. I wasn't saying that my client was contesting that, but that's what she reported to the police. So thank you.
Ms. Armstrong, they both reported that he was trying to help her put her name with tape on her knives. Somebody who's completely blind can't do that. And so representing to the court that this man is completely helpless and couldn't be helping somebody with knives and it must be a lie is just in bad faith. That's what I was pointing out. It was his statement that he was engaged in helping her put tape and decorate her knives. Okay?
She made the statement. That's all I'm saying. Thank
They
you.
both did, sweetheart.
Okay, let's not do that, okay? Let's be respectful and maintain that type of
There's no need to argue. I just don't understand why we would try to perpetuate
I understand that,
distrust here.
but Ms. Armstrong she's been in front of me many times before. The sweetheart language, that's inappropriate, Ms. Allen.
Thank you,
Okay.
Your Honor.
All right. So good luck to you, Mr. Doucette.
And I'm pulling up the bond order in Mr. Doucette's bond. I believe it already addresses contact with their children. And so I think a bond order related to following any previous orders of the court related to those kids is absolutely appropriate. Thank you.
Thank you. All right, who do we have next there?
Yeah, position number 5, Mr. Dello. Diallo.
Sorry, tell me again who this is.
Position 5,
Mr. Diallo?
yes.
All right. Good afternoon, Mr. Diallo. You have been charged in case 25 CR 002099A with criminal trespass and damage to property. It's my understanding that this is Mr. Diallo's first arrest. Ms. Westman?
Your Honor, we do know that there is an open Sandy Springs case in municipal court, and there has been prior police involvement. He is a juvenile, so that's why there may be some things that we aren't seeing. But
Okay.
there is an open Sandy Spring case involving violence with his mother.
Okay. Thank you. You can proceed, Ms. Westman.
Thank you, Your Honor. On April 21st, 2025, an officer was dispatched to a domestic violence call at 748 Park Trail in Sandy Springs. Upon arriving, he met with the victim, Mahawa Diaby, who's the mother of the defendant. She said that the defendant had taken her laptop from her room. The defendant is 17, and he had said he needed to use it to complete a court-ordered anger management class. The officer asked where the computer was, and it was found in the laundry room. The victim located it covered by a blanket in a chair. The victim shared with the officer that the defendant has a long history with the police and juvenile court. She was afraid things would escalate that night because she knew his behavior patterns. The officer told the mother and son to separate for the evening and to call him if they needed any further assistance from him. As the officer was walking out, the victim, Miss Diaby, came out and said that her son was acting up again. She said that when the officer left, her son came into the kitchen. He turned off the lights and called her a bitch, and then took her cell phone, dropped it on the ground. And the mother, Miss Diaby, said that she was afraid of injury, of being hit or slapped. At that point, the defendant was taken into custody. We have spoken to the victim today. She's going to try and be on the Zoom, but wasn't clear if she would be able to. But again, she's the mother. She stated that this is an ongoing issue, that the defendant's behavior is getting worse and worse, that he has multiple cases in juvenile court where he has been violent towards her. Ms. Diaby said that the defendant has pulled a knife on her, punched holes in the walls, and threatens her, that the defendant has anger issues, and she does not feel safe with the defendant at home. Ms. Diaby stated that she has tried to get the defendant help, but he refuses. She said that part of the defendant's probation is for him to attend school, and he doesn't go. Ms. Diaby also stated that she doesn't know what to do at this point. She doesn't want contact with the defendant and says he cannot return to the residence. So at this point, we are asking for a $1,000 surety bond, no further contact with the victim, stay away from her home, Ms. Diaby's home and her workplace, no alcohol, drugs, or weapons, a family violence intervention program. And right now we would sound for Ms. Mahawa Diaby.
If Ms. Diaby is on the line and wishes to address the court, now is your opportunity. Ms. Armstrong?
Your Honor, out of consideration of Mr. Diallo's age and his lack of criminal history, would ask for a signature bond through pretrial services. I don't my understanding that he may be able to live with his father. I'm not able to provide the court with that address today, but I defer to the court on the issue of bond. Thank you.
Armstrong, he's 17.
Yes, Judge. That's my understanding. That's what I see in the records from the
Okay.
That's what I see too.
If you can, I don't want to put a 17-year-old out on the street.
Understand.
So if you or your office can find somewhere for him to go, I'm more than happy to reconsider this at another SEA calendar. I won't be here tomorrow, but I will be here on Thursday. And if you want to address it with whomever's here tomorrow, that's fine with the court. But as far as today goes, I'm going to accept the state's recommendation of $1,000 good bond. No further contact with his mom, stay away from her residence, no drugs, alcohol, weapons while out on bond. We can find a locate somewhere for him to reside, someone who will take him in. I'll modify that bond. So would you like me to place him on the calendar for tomorrow? Or I could also place him on my SAP calendar next Tuesday.
Let's do tomorrow. I'll reach out to the proper people. I appreciate the opportunity to do that. Thank you.
Okay. All right. So knowing that, again, I won't be the judge tomorrow, but I'm happy to have you place him on there to see if they will consider modifying the bond. All right.
Thank you.
So that will be the court's order at this time. Good luck to you, Mr. Diallo.
Yeah, Your Honor. Your Honor, I didn't get that.
Okay, it's $1,000 good bond. Do you need anything more than that? You need the rest of the conditions?
That was all.
Okay, very good.
Next is position number 11, Mr. Moncrief.
Afternoon, Mr. Moncrief. You have been charged in case 25 CR 002101C with battery family violence and simple battery family violence. Is there a history, Mr. Howard?
For 2018 FTA, 2016 burglary conviction, 2015 burglary in the second, possession of tools, obstruction, possession of a Schedule 4, wearing hood, mask. Those were first offenders.
Thank you. Ms. Harrison, good afternoon.
Good afternoon, Judge. This offense occurred on April 20th, 2025. The incident location is 2184 Penelope Street, Northwest Atlanta. Officers were dispatched to a fight call at the incident location. When they arrived, they noticed a black male looking towards the officers from the rear of the house. They identified this person as the defendant, and they noticed that he looked as though he was intoxicated. They tried to speak with him, but he became irate, so they detained him at that point. They then knocked on the front door and encountered Tiffany Scott, who's the victim in this case, and her brother, who both reside at this residence. Ms. Scott informed officers that her and the defendant are in a relationship and have been in a relationship and residing together for the last 4 years. She stated that they were driving back from the defendant's mother's house. And when they arrived at the house, the defendant tried to urinate at the rear of the house, and she told him she wasn't going to let him do that. And he asked her, what are you going to do about it? And she told him, don't do that again. And he responded by spitting on her and punching her several times in the face, leaving visible knots on her forehead. So she then told him to, stay outside and sleep in the car because she didn't feel safe with him in the house. Officers did speak to the defendant to get his side of the story, and he stated that he admitted to punching her in the face area after she said something to him. The other witness on the scene, which is Mr. Grant Scott, the victim's brother, stated that he was inside the residence. He didn't see the altercation, but he heard the noise from it occurring outside. In addition to the nodding on her head, officers also observed what looked like a bite mark on the victim's bottom lip. We were unable to speak with her today, but in light of the defendant's prior criminal history and, of course, the FTA, we are asking for a $2,000 surety bond, no contact with the victim. We are asking for a stay away from the incident location with the exception of a one-time police escort to collect his belongings, and no alcohol, drugs, or weapons while on bond. And we'll sound for the victim just in case she joined the Zoom today. And that's all for the state, Your Honor.
Thank you. Ms. Tiffany Scott is with us and wishes to address the court. Now is your opportunity. Mr. McLean.
Thank you, Your Honor. 32-year-old Christian Moncrief is a graduate of DeKalb County High School. back in 2010, and he drives trucks. They are straight trucks, the 18 to 20 foot variety, delivering for a beverage company, and he's been doing that for the last 6 years. Considering when that prior arrest history was, Your Honor, we would ask the court to consider a signature bond for this case. I've been in touch with his mother. He can live where the court says it's appropriate, or he can stay away from wherever the court says is appropriate, and he would follow the court orders, we believe. Thank you.
Okay, for the battery, it will be a $2,000 signature bond through pretrial level 2. For the simple battery, $1,000 signature bond through pretrial level 2 makes for a total of a $3,000 signature bond through pretrial level 2. No further contact with Ms. Scott. Stay away from her residential address. He can have a one-time escort to retrieve any belongings, law enforcement escort, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Moncrief. You're welcome.
Next is position number 18, Mr. Smith.
Good afternoon, Mr. Smith. You have been charged in case 25 CR 002106F with simple battery, family violence, criminal trespass, willful obstruction of law enforcement officers, and public drunk. Is there a history, Mr. Howard?
16 open trespass in state court, 2016 FTA, 2013 and 11 probation, and 06 ag assault battery, entering 911 call, obstruction first offender.
Thank you. Ms. Melgizo, good afternoon.
Good afternoon, Your Honor. How are you?
Doing well. Hope you are as well.
Thank you. Yes, Your Honor. This incident is from April 20th, 2025. The location is 1030 Delmont Terrace, Roswell, Georgia. Your Honor, on the day of the incident, officers responded to the location in regards to a domestic disturbance. The victim in this case is Ms. Jill Smith. She is the mother of the defendant. The victim told officers that the defendant had been drinking. He became angry when he was locked outside. He then punched through the glass of the kitchen door. And in the process, he cut his hand. Officers did observe the broken window in the kitchen door and could see blood droplets on the floor. Officers walked outside to the backyard. On the day of the incident, after the victim cut his hand, he grabbed the victim by her arms and smeared blood all over her arms. He was not at the location, but officers went outside to the backyard to look for the defendant. He found him standing behind a fence in the shed of the neighbor's property located at 436 Delmont Terrace. Officer B. Pawlowski of the Roswell Police Department engaged with the defendant, and he responded in a drunken nature by beginning to swear at the officer. The defendant's speech was slurred, and officer could smell the odor of an alcoholic beverage coming from the defendant. And later on, officers did find a bottle of vodka on the defendant's person. Other officers arrived to the location, and the defendant still refused to cooperate and continued to yell and swear at the officers. The officers finally had to physically remove the defendant from the area and took him into custody. Your Honor, this defendant has an open case, 23 CR 007244F, criminal trespass and damage to property, same victim, his mom, same location. The bond order was signed by Judge Mincy. The conditions for that bond was to stay away from this location and no further contact with the victim. It was a signature bond through the jail. It was $1,550. Your Honor, we did speak with the victim. She confirmed the events in the warrant. She said that he gets like this when he drinks. She has some concerns regarding MH. She wants the defendant to get help from MH issues. She doesn't want any contact with the defendant. She wants the defendant to stay away from the location. Your Honor, the state's recommendation is a $1,000 surety bond, social service visit to determine BHET, and alcohol and drug evaluation and treatment. Stay away from 1030 Deltman Terrace, Roswell, Georgia. No further contact with the victim, Jill Wyatt Smith. No alcohol, drugs, or weapons while on bond. And the reason why we're asking for a surety bond is the risk of reoffending. Again, he already had orders not to come back to the location. And if we can now sound for Miss Jill Smith, in case she wishes to be heard. That is all for the state.
Thank you. Ms. Smith, I see you there. If you would like to address the court, you certainly don't have to, but if you would like to, I'll need for you to unmute yourself there for me, and I'll have to swear you in. Yourself, Ms. Smith? Can't hear you, so are you able, is there somebody there that can help you?
Stanton needs
Okay.
help.
Okay, hold on.
He needs to go somewhere he can get help.
Ms. Smith, I'm happy to hear from you, but you'll have to raise your right hand for me, please.
I put it on unmute.
Okay, I can hear you. Can you hear me?
I can.
Okay, can you raise your right hand for me, please? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
I swear.
Okay, anything else that you'd like to tell me other than he needs some help?
He's been talked to frequently about his drunkenness, and he has psychotic episodes from his drunkenness that he probably doesn't remember what he's doing at the time. And that's when he usually exhibits the destructive, abusive language and violent behavior. He's broken one of the windows in my kitchen door already once by just hitting it with the back of his hand. And I'm not sure if the one coming through from the carport was intentional, but he probably thought it was the storm door. Instead, it was the inside kitchen door because he'd already opened the storm door and then he just hit it. He probably thought it was the storm door, which has got the plexiglass on it. But he was talking to someone on the phone, and the person on the other end was using disgusting and abusive and nasty language too. And he may have been just trying to help another situation. I honestly don't know. But this has been happening multiple times. It happened at Wesley St. James with him when I lived there too. And people were coming in and out of my apartment at all hours of the day and night when I was there and sleeping or when I was at work. And I just can't be engaged in any of that kind of behavior ever again. And he told me he was going to go back and get help, per se, like at SLA or some other place that helps you work and treat your alcoholism or drug abuse from a facility that they find jobs, help you find jobs, and then you work and you pay to live there. Then you may earn a living as well. And he needs to go someplace like that. I've already talked to him about it. I can't be around him anymore with the way he's been behaving. And some of the people he's known since he was younger are still engaging with him on the phone and stuff. And I have his phone at the house now, his keys and wallet, and I don't mind bringing him clothes wherever he goes, but he can't come back here. He lost his phone, his Librium, and his blood pressure medication the first time I called the police over here. Someone either took it in one of those things in a shuttle or at Rice Street or Alpharetta, and he never received his phone, his Librium, or his high blood pressure medicine back either. So I'm not sure what happened to that either, which to me that was wrong as well. So
Okay, Ms. Smith, he has already been ordered by another judge not to be around you or your residence, okay? He's in violation of another judge's court order, so you cannot allow him to be around you or your residence. He should not have been around you to
I
begin with.
understand.
Okay, I'm going to order that he is not to be around you or your home at this time, but I will give him the opportunity to get his belongings back. Thank you for being here this afternoon, ma'am.
Oh,
We
thank
appreciate it.
you.
You're welcome. Mr. McLean?
Your Honor, 39-year-old Stanton Smith is a graduate of North Springs High School in 2008. He also attended Argosy University for a semester to study college courses. Your Honor, he works for a company that does delivery of food, so he does the shopping and then the placement of the food in the cart and then takes it to the customer. He's done that for a while, and for several years before that, he worked for a company that makes mattresses, and he also drove the truck for them. So he's quite industrious, and he is an educated person. If I realize what's being said about the 23 CR case and the bond conditions, but if Your Honor could see any way to trust him on straightening up that situation, we would ask for the lowest possible bond. In this situation, Your Honor, signature bond might not be possible, but if it is, we would ask for it. But Your Honor, he certainly is smart enough to get a shelter, find a place to stay away from the residence. So we would ask the court to consider the lowest possible bond. He does have a job.
Okay. He's been given the opportunity to stay away previously, and he was released on a signature bond through the jail. I'm not going to give him that opportunity this time. Apparently, he's violated that order. It's going to be a $250 good bond per charge, makes for a total of $1,000 good bond. No further contact with Ms. Smith. Stay away from her residential address. He can go back to that address on one occasion with law enforcement to retrieve any belongings, no drugs, alcohol, weapons while out on bond. I also want him to have a social worker visit to assess for BHET.
Yes, Your Honor.
Right, very good. Good luck to you, Mr. Smith.
Next is position 8, Mr. Hartnett.
Good afternoon, Mr. Hartnett. You've been charged in case 25 CR 002093D with willful obstruction of law enforcement officers. Is there a history, Mr. Howard?
Well, on probation out of Clayton County, criminal damage to property. 2 probations from 2018, 2016 entering auto, first offender. 2016 FTA. 2015 theft by taking, theft by receiving conviction. Another 2015 arrest, theft by taking, obstruction conviction. I think he's one out of Clayton County.
Ms. Harris?
Yes, Your Honor. This offense occurred on February 12th, 2025. The incident address is 1600 Connolly Drive in East Point, Atlanta. That's an apartment complex called Aya Towers. Officers responded to reports of a suspicious person. The witness gave a description of a light-skinned male who was looking inside of multiple vehicles and pulling on door handles. They gave the description that the male wore a black hat turned backwards, a dark gray shirt, camouflage pants, black shoes, and a black book bag. When officers arrived on the scene, they canvassed the area of Connolly Drive at the intersection of Norman Berry Drive and observed the defendant matching the description that was provided by the witness. Officers attempted to approach the defendant, and he broke off and running away from the officers, and a pursuit ensued. Officers were finally able to subdue the defendant and identify him. Based on his previous criminal history, and I did pull up the warrant as well. The state's recommendation is $1,000 surety bond. Stay away from the incident location. No alcohol, drugs, or firearms while out on bond. And that'll be all for the state, Your Honor.
Thank you. Ms. Armstrong?
Actually, if I can ask for some clarification, I see the accusation that's been filed is for one count of obstruction. So I saw there was two counts, but I just want to make sure it's just one, correct?
Yeah, it's one on this accusation. That's correct.
Perfect. Thank you. I just didn't want to argue something that would be wrong. So thank you, Judge. We're asking for, it's my understanding signature bonds are not, or we can't assign signature bonds for obstruction charges anymore. Is that correct?
No, you can't, through the jail, you can't, but you can do it pre-trial.
Thank you for clarifying. We were asking for a signature bond through the jail based on my reading of the accusation. The defendant did not offer any violence to the officer. It appears the accusation concerns fleeing. My client reports that he would be unable to post any bond. He's unemployed and he has some housing concerns. So he was hoping to submit a job application today, but that's not happening. So we just asked the court to consider a signature bond through the jail. Thank you.
Ms. Harrison, do we know what he's wanted out of Clayton County for?
I can pull it up. I thought that was an obstruction charge too, but let me see. Just 1 second.
Probation.
Probation violation?
Correct.
Okay, thank you, Mr. Howard. It's going to be a 250. Thank you, Ms. Harrison. I appreciate you looking for me. A $250.
Thank you, Mr. Howard.
Be a $250 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Howard.
Next is position 2, Mr. Brent.
Good afternoon, Mr. Brent. You've been charged in case 25 CR 002103B with battery, family violence, cruelty to children in the third degree, and reckless conduct. Is there a history, Mr. Howard?
7, 2021 simple battery. Terrorist threats. That was no bill. 2019 battery conviction.
Okay, before I go on, young man that's on the iPhone there, can you hear me? Yes, sir. This is a court proceeding. I'm happy to have you here this afternoon, but you're going to have to stop chewing on that gum for me, okay? So treat yourself as if you were actually in court with me and take the gum out. Thank you. Ms. Westman.
Thank you, Your Honor. The date of this offense was April 21st of 2025. It occurred at a daycare called Harvest Rain Early Learning Academy in Fairburn, Georgia. The officer was dispatched to a daycare in reference to a physical fight between two parents of a child who's 5. The officer observed the defendant shouting at the victim, Miss Taisi Todd. The defendant was advised to hand over the child to a daycare worker so the officer could talk to the parents and investigate. The defendant said that he has his child from Sunday through Wednesday and that he checked out his child from daycare and went back to his car and put the child in there. The defendant said that the mother arrived saying she was going to take the child. The defendant said that he told Miss Todd that the child did not want to go with her. The defendant advised that Miss Todd was trying to get inside the car and he was blocking her when the defendant admitted that he pushed her and she fell. Miss Todd, however, said that she and the defendant were having a normal conversation and the defendant said he was going to go to work and was going to drop the child at a female friend's house. Miss Todd said she would take the child and he didn't have to drop off her child at a friend's house. Miss Todd said she was holding the child in her arms and they started arguing over her taking the child. And the defendant said she couldn't, then pulled her shirt and pushed her on the ground while she was holding the child. Miss Todd had an open cut and bruising on her arm. Fire and EMS were called and she was checked. Further, we spoke to the victim today. The victim and the defendant are not in a relationship. Ms. Todd said they don't live together. However, they share this child. She confirmed the events in the warrant. She said that the defendant was supposed to get the child on Sunday, but did not pick the child up. Ms. Todd said that she dropped the child off at school Monday morning and had been texting the defendant asking if he was going to pick the child up. Ms. Todd said that she never received a response back, so she went ahead and showed up at the school, and she and the defendant arrived there at the same time. Ms. Todd said the defendant had never been violent with her in the past. She believes that the situation just got out of hand. She did say she's not in fear of the defendant and does want to continue contact. She said she's going to be on Zoom, so we'll see if she's here. At this point, we're very concerned about being pushed with a child in your arms, whether the victim wants to continue contact or not. There is a child here that witnessed this, that was there when she was pushed. Based on the 6 arrests, the battery conviction, we are going to ask for a surety bond of $3,000, no further contact with Ms. Todd or the minor child. Stay away from her home and workplace, no alcohol, drugs, or weapons, and a family violence intervention program. At this point, we would sound for Ms. Todd.
Ms. Todd, good afternoon. If you would like to address the court, I'll need for you to raise your right hand for me, please, ma'am. Do you swear or affirm the testimony you're about to give before this court will be the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can place your hand down, ma'am. What would you like to tell the court?
First and foremost, I want to apologize for the situation at hand. Like I did tell them, I feel like the situation was blown out of proportion. I do feel like the story has been mixed up. That my son was not in my hand when I did get pushed. My child was with his dad. He was not in my hand at all. I mean, he did see the altercation, but he was not in my hand. I know I can't control what y'all charge him with, as far as the cruelty to child, but I do want to say, like, despite the situation, my baby dad is a great father, so I don't feel like he shouldn't have no communication with his son. Like, he does pick his child up, he does get his child, he pays his child support. I don't have no problem with that. As far as, like I said, I just feel like the situation got at hand. It didn't necessarily have nothing to do with a female. I told him as his mother, like, I will keep my child with me. You don't have to drop him off to nobody. I don't know if my baby dad was having a bad day or what was going on, and I probably triggered whatever he had going on, but I feel like the whole situation, like I said, was blown out of proportion. I'm not in fear. As long as I've been known him for 6, 7 years, he's never put his hand on me. He's never been violent. Nothing like this never has happened around my child. So I just do want to make that known. But whatever y'all do decide to do, but I know I don't want to press no charges or nothing against him.
How old's your son, Ms. Todd?
He's 5.
5? Okay. Thank you for being here. Did you have anything further, Ms. Westman?
Yes, Ms. Todd, have you spoken to the defendant since he's been in jail?
No, I have not. I did, reach out to his mom and his dad to let them know because his car and all that stuff. But other than that, I haven't reached out or talked to the defendant at all.
Thank you. I appreciate you being here, Ms. Todd.
Thank you.
Ms. Armstrong?
Your Honor, we would ask if the court would consider bond through pretrial services for the defendant to start the FBIT program. Seems like that could be a benefit in the situation that the state's presented. As the victim did state, he pays child support. And it's my understanding, well, strike that. He is gainfully employed. He earns a good salary in his job, and out of respect for the defendant, I don't want to say that on the record, but we can say with full candor to the court that he is employed. And we would also ask that Your Honor be inclined not to impose a no contact provision between my client and his child it's my understanding, his parental rights are protected. And if at most, if the court were to restrict contact with his child, it would be with a third party visitation or a third party to monitor the contact between his child and the victim. Otherwise, we defer to the court.
If I can, Ms. Todd, we did see that there was a legitimation that was canceled out. Is there court mandated supervision and custody, or is it
No.
voluntary?
It's
Okay.
no court, nothing. He just get his child on the days that we agree on, and I keep him other days.
Okay. So there's no legal custody there, correct?
No, it's not.
Thank you.
Okay. Nothing further for the battery. It will be a $2,000 signature bond through pretrial level 3. For the cruelty, a $500 signature bond through pretrial level 3. For the reckless, a $1,000 signature bond through pretrial level 3. Makes for a total of a $3,500 signature bond through pretrial level 3. Again, the Family Violence Intervention Program. No further violent contact with Miss Todd or the 5-year-old child. No drugs, alcohol, weapons while out on bond. Good luck to you, Miss Todd. You as well, Mr. Brent.
Thank you.
Next is position 9, Mr. Jackson.
Good afternoon, Mr. Jackson. You have been charged in case 25 CR 002092C with theft by shoplifting. Is there a history, Mr. Howard?
Fourth arrest, you got open shoplifting in DeKalb County. So I wouldn't necessarily recommend it, me personally. 2018 terrorist threats dismissed, and another 2024 shoplifting.
Thank you. Ms. Harrison?
Yes, Your Honor. This incident occurred on April 21st, 2025 at 2045 Donald Lee Howell Parkway in Atlanta. It's a Family Dollar store. Officers were flagged down in reference to a male taking items from the store. The manager, is Miss Jackson, was behind the defendant when the officers arrived on the scene. The defendant had walked out of the building via a side door exit where only employees had access to the door. He was placed into custody and in the back of the patrol car. He did admit to stealing from the store, and he said it wasn't his first time stealing, but he is going through hard times, so that's the only way to get things. We are aware of his open charges. I believe they're out of DeKalb County. So the state's recommendation in light of those charges is a $1,000 surety bond to stay away from the incident location and no alcohol, drugs, or weapons while on bond. That'll be all.
Armstrong?
Yes, Judge, thank you. Mr. Jackson recently attained housing. That was through a nonprofit organization. And out of respect for Mr. Jackson, I'm not going to name that organization on the record, but he has recently applied for disability. And we're concerned that if he remains in custody, he will lose that housing opportunity. We're asking the court to allow him to be released to a signature bond through pretrial to take an anti-theft class and whatever other conditions the court deems appropriate. Thank you.
Okay, it will be a $5,000 signature bond through pretrial level 2. Stay away from all Family Dollar stores. No drugs, alcohol, weapons while out on bond. I'm going to let you out, Mr. Jackson, but if you don't show back up or if you violate any of these conditions, you'll be right back where you are. Good luck to you, sir.
Next is position 14, Mr. Fan.
Good afternoon, Mr. Fan. You have been charged in case 25 CR 002098F with promoting or organizing an exhibition of illegal drag racing or laying drags and reckless conduct. Is there a history, Mr. Howard?
4. 2024 reckless driving conviction. On probation for 6 counts of promoting or organization of exhibition of illegal drag racing. 6 counts. That's 22 CR 008-461A. That's all.
Ms. Harrison?
Yes, Your Honor. Okay, just bear with me. It's a bit lengthy here. Okay. This incident actually occurred on September 2nd of 2024. The location incident is 496 Plasters Avenue Northeast. So there's a gathering. The purpose of this gathering was to conduct a video shoot for a music video. The video was for a rapper that goes by the name, I believe it's Ian. So at the gathering, there were several exotic high-end vehicles. Many of the vehicles displayed decals associated with the Pink Flamingo USA LLC, which is an arts and entertainment and recreation business run by the defendant. The defendant has these open charges, so investigators were actively monitoring his actions. And the auto crimes enforcement noticed the Instagram profile, Chris Pink Flamingos USA and Pink Flamingos USA, promoting the music video that was going to be released on the rapper Ian's page. So they shoot the video and Ian posts shots from the music video on his Instagram page. And you can see them standing in the center of the intersection of Armour Drive Northeast and Plasters Avenue. There's 2 BMWs doing donuts around the subject of the music video. The auto crimes enforcement officers actually responded that day to the incident that evening, but by the time they arrived, the group shooting the video had already left. So officers did observe the fresh damage to the streets from the donuts that took place earlier. They also found several other shots from the video that showed various people driving recklessly down Interstate 75. And there's shots of people hanging out of car windows and vehicles blocking the free flow of traffic, driving side by side at a slow speed. And then also driving at fast speed, passing other vehicles. There were no permits pulled by anyone to stop traffic or do any of these stunts on the public roadways in Atlanta. And then there's a YouTube video that's posted with the behind the scenes of the music shoot. And the video shows the defendant present at the event. It shows inside one of the vehicles that's also on the other videos, and the defendant's voice can be heard giving instructions to the drivers, like coordinating their activities. They also, officers were able to pull security camera footage from the gas station at 496 Plasters Avenue and confirm that the shoot did take place. They confirmed that the defendant was there along with the rappers, and the defendant appeared to be giving directions to cars and people participating in the music video. There were also social media posts that showed the defendant actually organizing the video shoot with 2 other people, and he sent a message saying that he had a major play on Monday, September 2nd, 2024, and people wanted to shoot a quick video for Instagram, and it was going to be huge. And he actually said in the messages, he'll figure out a time and place and send it to you guys, but it's going to be posted on the block and then some sliding, but nothing too extra. And sliding is known to detectives to be used in this context as laying drag in a circular motion. Okay, so in light of the defendant's criminal history and the fact that he is on probation and is violating his conditions for the open charges that are the same charges as he's currently facing, the state's recommendation is a $2,000 surety bond, $1,000 on each charge, no alcohol, drugs, or weapons while on bond. And I believe that will be all for the state, Your Honor.
Okay, thank you. Mr. McLean?
Thank you, Your Honor. 28-year-old Christian Fan it does have a stable address in the metro area. He was educated at Berkmar High School, later went to a local college, 2 semesters there studying the core classes, and decided at that point to join the military, which he did. And then when he came out of the military, he's been working as a security officer, as an entrepreneur. And, Your Honor, under the circumstances, one thing I would, of course, remind the court is it is from last September, and I believe the warrant was obtained in October of last fall. We would ask the court under these circumstances to consider the lowest bond that is reasonable. We would ask the court to consider whether that would be a signature bond. We would ask for that if it is possible. And if not, then the $1,000 surety bond. Thank you.
Okay, it'll be $1,000 good bond on each charge, makes for a total of a $2,000 good bond. No drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Fan. Who do we have next?
Position number 16, Mr. Rainey. Hey, Your Honor, do you know the ETA for the Spanish interpreter?
She was supposed to be here already. So let me have Miss Grace get back in touch with her to see if to see what her ETA is. But I know that she let us know that she was going to be here promptly.
I'll check on it, Judge.
All right, thank you. Mr. Rainey, good afternoon. You have been charged in case 25 CR 002104Y with fleeing or attempting to elude a police officer, speeding, failure to obey signs or control devices, reckless driving, driving while your license was suspended or revoked, improper or erratic lane change, 2 counts, and a center lane violation. Is there a history, Mr. Howard?
Fifth arrest, 2023 probation. Marijuana from 2022. A 2022 carrying weapon without a license conviction. 2021 possession of a pistol or revolver by person under 18 years conviction and wanted out of Riverdale.
You know what he's wanted out of Riverdale for?
It's
Not
an
for look.
FTA, failure to appear.
And do you know what charge that is, Ms. Elgizo?
Fortunately, I don't, Your Honor.
Okay, that's fine. Thank you. Yes, you can proceed.
Yes, Your Honor. This incident is from April 21st, 2025. On the day of the incident, officer was sitting on the side of the roadway along Jonesboro Road at Old Jonesboro Road inside the city of South Fulton for speed enforcement. Officer observed a car driven by the defendant traveling at what appeared to be a high rate of speed. The speed was checked and it was 95 miles per hour in a 55 miles per hour zone. Officer initiated a traffic stop while in a marked patrol unit by turning on the patrol unit emergency lights and sirens. As he was attempting to catch up with the vehicle, the defendant did not make any attempt to stop, but instead accelerated and made several improper lane changes when it was not safe to do so from the number 2 lane to the number 1 lane. As officers got behind the vehicle, the defendant failed to obey the traffic light showing red at the intersection of SR 138 and West Fayetteville Road. The defendant then improperly used the center lane to pass vehicles without intending to turn. The defendant continued on SR 138 at speeds exceeding 100 miles per hour. The defendant then took a left turn onto McElroy Drive, and he continued at a high rate of speed through several other streets. Once the driver turned right onto Dexter Drive, he failed to maintain his lane by driving his vehicle off the roadway into the ditch, crashing his vehicle. After placing the defendant in the patrol unit, the officer searched the car and found the defendant's wallet on the floorboard of the driver's side seat. Officer ran a GCIC, and the defendant's information came back as him having a suspended driver's license for failure to appear in the city of Riverdale, Georgia.
Yeah.
Your Honor, the state's recommendation is a $4,000 surety bond, no driving without a license, to be released to Riverdale, no alcohol, drugs, or weapons while on bond, Your Honor, this defendant did have a set bond at $5,600. The state is recommending a $4,000, and it was a surety bond, what it was set at. We are recommending a $4,000 surety bond, and the reason is the danger to the public. That is all for the state.
Thank you, Your Honor. Cortez Rainey is 21 years old. He has the 12th grade education, and he's finishing up by going for the GED. So he is paying attention to his education. He's worked at a warehouse doing the picking and packing as opposed to the driving for the last many months. And before that, worked as a mechanic, fixing brakes, oil, everything in a car. Your Honor, he's only 21 years old. He does have a stable address in Fayetteville. We would ask the court to consider the lowest possible bond to secure his return to court, and we would ask the court to consider actually a signature bond if possible, but if not, then a $1,000 to $1,500 bond.
Okay, for the fleeing and attempting to elude, a $500 good bond. For the speeding, a $500 good bond. For the reckless driving, $500 good bond. For each of the other charges will be each a $100 good bond. Makes for a total of a $2,000 good bond. No driving without a valid license. No drugs, alcohol, weapons while out on bond. Did you get that, Ms. Bridgewater?
I have it, Your Honor.
Okay, very good. Thank you. Good luck, Mr. Rainey.
Next, Your Honor, is position number 17, Mr. Riley. Have a seat.
Good afternoon, Mr. Riley. You have been charged in case 25 CR 002105J with driving under the influence of alcohol, driving on the wrong side of the roadway, and possession of an open alcohol container. It's my understanding that this is Mr. Riley's first arrest. Ms. Malgiza?
Yes, Your Honor. This incident is from April 21st, 2025. On the day of the incident, officer observed a vehicle driven by the defendant on the wrong side of Interstate 85 South. Officer went head-on with the defendant to stop him. Once stopped, officers observed bloodshot, watery eyes and detected the odor of an alcoholic beverage emitting from the defendant. The officer determined that the defendant was less safe to drive, and the defendant was arrested. Officer found an alcoholic beverage container, which contained Tito's and Coca-Cola in the defendant's car. Your Honors, the state's recommendation is a $2,000 surety bond, no alcohol, drugs, or weapons while on bond.
Mr. McClain?
Your Honor, thank you. 40-year-old Mr. Riley is from Palmetto, and he has a stable address there. His phone numbers are stable. He has good community contacts. He was educated with an Associate of Science in Information Technology from an Institute of Technology called Antigua and Barbuda International Institute of Technology. They abbreviate that ABIIT. He has certifications in Cisco, Microsoft, ISC squared. I'm not sure what the last thing is. Your Honor, he is working in capital management, which is an investor group. He's been doing that for 9 years, and this is his first arrest. Even though it is a DUI case, we would ask under these circumstances for the court to consider a signature bond.
Okay, for the DUI, it will be a $4,000 signature bond through the jail. For each of the other charges will be a $500 signature bond through the jail for each charge. Makes for a total of a $5,000 signature bond through the jail. No drugs, alcohol, weapons while out on bond.
Your Honor, if you could place courtroom 1 when they log on, and Ms. McLeod and the Spanish interpreter into a breakout.
Okay. So we're done with Mr. Riley here. Good luck to you, sir. And so Ms. McLeod, are you with me?
Have a seat. On the second row.
Interpreter, thank you for joining us this afternoon.
Good
Let me go ahead and swear you in so we can get that done. Do you swear or affirm that you will translate from Spanish to English and English to Spanish to the best of your ability?
I do.
All right, very good. Thank you. So let's place Madam Interpreter, courtroom 1 and that room. While we do that, who do we have next in courtroom 2?
Position number 10, Mr. Johnson.
Excuse me, Judge. What attorney is going in on the
I
breakup?
believe it's Miss McLeod, so she's not not there. Can someone give her a call to let her know that we're ready for her?
I'll call it, Judge.
And
Okay, thank
he's doing the person whose name is Adrian
Okay.
and I have the person whose name is Adolfo Montez. They are related. They're not brothers. It's uncle nephew relationship, and I'll need her services after that.
Okay, who is since we can't get whose client is this in courtroom 2?
It's my client.
Okay, all right. So we'll go ahead and so as soon as we get Ms. McLeod on the line, we'll place those into a breakout room. Then we'll place Mr. McLean when they come back out. I'm sorry. Tell me again, courtroom 2. Who do we have there?
Position 10, Mr. Johnson.
Okay, thank you. Good afternoon, Mr. Johnson. You have been charged in case 25 CR 002107J with giving false information to law enforcement. Is there a history, Mr. Howard?
3rd, 2019, battery DV dismissed and wanted out of Morrow. Probation for traffic.
Okay, thank you. Ms. McLeod, we'll place you into the breakout room. Yes, Ms. Malgiza.
Sorry, I was muted. Yes, Your Honor, this incident is from April 21st, 2025. The location is 1336 Deerfield Point, Milton, Georgia. On the day of the incident, officers responded to the location regarding a domestic dispute. Kareem Murray opened the door and told the officers, and the officers asked him if he had heard an argument. Mr. Murray explained that the neighbors must have called the police on him and his roommate. The roommate is Mr. Johnson, the defendant, because they were arguing. While talking to the defendant, officers could smell an alcoholic beverage coming from the defendant, and the defendant seemed intoxicated. Both parties stated that they were in a verbal altercation, but that nothing physical took place. However, the officers did observe broken glass on the kitchen counter. Officers asked the defendant to provide his information, and he became very guarded. He did not want to provide officers with his date of birth. After officers explained what he was asking, defendant provided a birth date of April 18, 1988. After conducting an investigation, officers found that the defendant's date of birth is actually April 27th, 1988. The defendant was arrested. Your Honor, there are 2 warrants. One is for a probation violation in Johns Creek. Let me see. This one is in Morrow, Georgia, and there is a failure to appear warrant out of Johns Creek for the defendant. Your Honor, the state's recommendation is a $500 surety bond released to either Johns Creek or Morrow. No alcohol, drugs, or weapons while on bond. And he did have a bond set at $1,000 surety. And Your Honor, we're asking for $500 surety. That is all for the state.
Can we mute there in courtroom 2? If that's you all.
You find out. Yeah. Okay, Thank you.
So, Mr. McLean, if it's okay with you, I'm going to release him to the hold. It'll be $1,000 signature bond through the jail, no drugs, alcohol, or weapons while out on bond. Does that suit you?
Oh, yes, Your Honor, it does. Thank you very much.
All right. Good luck to you, Mr. Johnson.
No. Next, Your Honor, is position number 3, Mr. Birdsong. Have a seat on the second row. He has a hold.
Yeah, we got a whole,
They said it.
Good afternoon. Good afternoon, Good afternoon, Mr. Birdsong. I'm doing well, thank you. Mr. Birdsong, you have been charged in case 25 CR 002095G with 2 counts of willful obstruction of law enforcement officers and fare evasion. Is there a history, Mr. Howard?
23. On probation out of Henry County for shoplifting. On probation out of the cab for 2 counts of burglary. Does have a probation hold out of the cab. 2022 FTA, 2020 theft by taking conviction. 2019 parole violation. Want me to keep going?
I have it here. Thank you, Mr. Howard. Ms. Westman?
Thank you, Your Honor. The date of the offense was on April 21st. It was at the Inman Park MARTA station at 1055 DeKalb Avenue. The defendant walked into a paid area behind a paying patron who was exiting. When the officers tried to place him under arrest, he would not put his hands behind his back when the officers ordered him to. As you've heard, there are 22 or 23 now prior arrests. He's a convicted felon with a history of burglary, arrest for burglary, family violence, battery, cruelty to children, entering cars to commit felony, in jail for burglary for 4 years and 4 different counts of second-degree burglary, prior obstruction of law enforcement, removing weapons from public officials. This is all his history. At this point, we would be asking for a $3,000 surety bond, a stay away from all MARTA stations, including the one at Inman Park, which is at 1055 DeKalb Avenue, and no alcohol, drugs, or weapons.
Ms. Armstrong?
Thank you, Judge. In advocacy of my client, I'm asking the court to consider a signature bond to the jail in whatever amount the court deems appropriate that would release into the hold. But ultimately, I do leave the issue of bond for the court's consideration. Thank you.
Okay, for each charge will be a $500 good bond, makes for a total of a $1,500 good bond. Stay away from MARTA, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Birdsong.
Okay, but is that, I had my MARTA fare, but it was 2 cars. And
Hold on, Mr. Birdsong, you'll be able to come back at a later time and dispute the charge if you like. Ms. Armstrong, if you'll be in touch with him, I don't want him to get himself in any more trouble. You have a right to remain silent, Mr. Birdsong, and so anything you say can be used against you.
I understand, sir. I was just trying to get to, I got 2 people, I got people that work here and that graded that verified it for me. And my wife OD'd, and I was trying to get to her. Once I got to her, I had to come back and get the kid. And it was a piece of candy on my Breeze card. Her card didn't have any fun on it. My card had funds on it. They both was together. And when I'm trying to show it to the officer, he tried to grab me, and then by the time he said it was too late. I had money on my cards. And you can look and see. I put the money on. I'm not on no probation. I'm not on probation, period. I'm on misdemeanor probation for Henry County. I'm not on no felony probation or none of that. And I was just asking, man, I had funds. I did come through and I was rushing. Yes, I did, because I was rushing trying to get back to the hospital. I just want to try to get me in the city so I can get to the next jail and get myself closer to home, please, sir. If
I
you don't-
understand, Mr. Birdsong. I'll see you back again at a later time. But at this time, that's going to be the court's decision. Good luck to you, sir.
You know, how long would it be? Come on, I'll let you know.
Okay, they'll let you know, sir. Anyone else that we can take courtroom to right now?
No, but I have a few announcements. And if
Okay,
go over the calendar before while the interpretation is going.
okay.
So
Go ahead.
the first announcement is position number 1 is a MH reset. Also position number 7 and position 15 bond was paid. Bond was posted.
Okay. So let me get these one at a time. Position 1 is reset for tomorrow, 4/23. Position number 7. Did you tell me that's a reset as well?
Make reset.
Okay, reset again till 4/23. And what was the other one?
15, position 15 bond was paid,
Okay, so 15 bonded out.
and that was all.
And that takes care of everyone except for the Spanish interpreter. Oh, okay. So while we wait for the interpreter, can we, Ms. Bridgewater, go over the calendar?
Yes, sir, we can.
Thank you.
Okay, once again, the reset date for the SAP calendar is going to be May the 6th. Position number 1 is reset till tomorrow. Position number 2 is reset further notice with a total $3,500 SOB through pretrial. Position number 3 is going to the SAP calendar with a total $1,500 good bond. Position number 4 is reset further notice with a $3,000 SOB through pretrial. Position 5, I have it as a $1,000 good bond. However, it is reset till tomorrow's calendar, the C calendar. Position 6 is going to the SAP calendar with a total $2,000 good bond. Position number 7 is reset till tomorrow on the C calendar. Position 8 is going to the SAP calendar with a $250 good bond. Position 9 is reset further notice with a $5,000 SOB through pretrial. Position 10, reset further notice with a $1,000 SOB through the jail. Position 11, reset further notice with a total $3,000 SOB through pretrial. Position 12, we're waiting on. Position 13, we're waiting on. Position 14 is going to the SAP calendar with a total $2,000 good bond. Position number 15 is reset further notice as the defendant has been released. 16 is going to the SAP calendar with a total $2,000 good bond. 17 is reset further notice with a total $5,000 SOB through the jail. 18 is going to the SAP calendar with a total $1,000 good bond. Are there any questions, comments, or otherwise?
Your Honor, just for clarification and to make sure we're all on the same page, position 1, the mental health reset for tomorrow, this will be the second time it's being reset. So I just want to make sure we're clear that there's no Riverside issues here. Thank you.
So, any other questions? Ms. Armstrong, on Mr. Diallo, if
Yes,
you are
Judge.
not, if you're not able to find placement for him by tomorrow, you can either request that he be placed on the SEA, if he can't make bond, be placed on the SEA calendar for Thursday when I'll be back. And if you can have someone find someone by that time, or if you want to place him on my SAP calendar next Tuesday, I'm willing to do that also. I just don't want him sitting if there's someone that is able to take him, but you can't find someone by tomorrow. Okay.
Yes, Judge. Thank you. And I did go ahead and email my social workers. So hopefully something can work out, but we appreciate your attention to this. Thank you so much.
And we can facilitate at least communication with mom.
Your Honor, I did speak with Mr. Diallo, and I am in the process of possibly getting in touch with a friend to see if that's somewhere that he can go.
Our understanding is he's currently enrolled in high school.
And that's why we wanted to keep it where it's like a friend that goes to the same high school, so that way we can keep him in school as well. So that is taken into consideration.
Great, thank you.
Thank you. I appreciate it. Okay, so let's see. As soon as Ms. Grace, as soon as they're done with Ms. McLeod's case, if you can go ahead and place Mr. McLean into the breakout room so that he can discuss with, I guess, is it a brother?
Nephew, Your Honor, and mine will be pretty brief because I've spoken with the state about the situation, and it's mostly explaining things to him.
Okay, very good. So we will be in recess until we're ready to go with the interpreter cases. Thank you all.
Your Honor, Your Honor.
Yes,
Hello?
ma'am. Yes,
Yes,
ma'am.
let me turn my camera on, please. This is the Moy White for Gary White. So just checking to see if Gary was supposed to be in court today, I was told. Because I really would like to address the court about Gary is still in the Fulton County Jail.
Ms. White, I don't have a Gary White on my calendar for today. Are you sure that it was on the misdemeanor
The assault,
first calendar?
yes, from 3 weeks ago.
Yeah. Was that on SAP today? We did discuss that case.
He was supposed to be on that. I didn't hear his case though. Get called.
Okay, hold on 1 second. Let me pull my SAP calendar and see what I did, and see if he was on my calendar. Give me just a moment.
Okay.
Ms. White, no, he was not on my SAP calendar today. Are you a victim in the case?
No, Gary is my son that was placed in the group home and shoved one of his roommates. And so the police locked him up instead of, they should have called crisis. So he's in the to jail and, you know, developmentally, cognitively, and retardation. You're not supposed to be there. And
Ms. White, I'm just saying that he was not on, he's not on this calendar today. I'm just trying to direct you to where we can find him. He wasn't on either of my calendars today. Miss Allen, are you able to
What I
pull
see in
his
the system is that it's reset to the 24th. It has been reset from SAP 3 times.
I don't see them.
Looks like
I can add a little bit to
the
that.
competency calendar. Yes, Mr. McLean.
Melvin Thompson with Diamonds in the Rough was trying to get a placement for him for housing as soon as possible, but he was waiting on a certain certification or a certain listing or approval from a state agency or a local agency to be able to do that. And we were just we check on it every other day just to see if and every day sometimes just to see whether or not that has gone through yet. So hopefully something's going to break soon.
So that's why I'm on today. And, you know, I was told that there was going to be a court date for Gary today because when I check into it, they just sent the email and have a tracking number. So they're just pulling their feet, and Gary is really having a hard time in jail. And so I'm asking the court, is there, could he be transferred to crisis, or what can be done to help him to get out of there?
It's my understanding that he's going to be on the calendar, the SAP calendar, which starts at 9 o'clock on Thursday. So we're happy to give you that link for Thursday so that you can be present for that case, okay?
Okay, how do I get that link?
Okay. Can we, Ms. Bridgewater, are you able to Put your email address in the chat, Ms. White, and I'll have someone email you the link for that calendar, okay?
Okay, thank you.
And who can I have accomplish that for me, please?
Me,
Thank you for volunteering, Ms. Bridgewater. I appreciate
you were
it.
looking right at me. I had no other choice. Okay.
Okay, can we go
I'll
ahead and
take care of it. Thank you.
thank you. We'll get you that link, Ms. White. Thank you.
Okay,
Can we,
thank you.
Mr. McLean and Madam Interpreter back and courtroom one back into a breakout room, please, so that they
Yes,
can
sir.
discuss. Thank you.
Hold on. Your Honor, I'm sorry. Give me 1 second. Please do. Thank you. I'll absolutely make it happen.
So, excuse me, did you receive it?
I'm going to forward you a consent bond. Ms. Falk prepared a consent bond and sent it to Mr. McLean and others involved. She just needed the name of mom. And I will get that, make sure Mr. McLean has it, and we'll make sure it goes right to your inbox. Okay?
Okay.
Okay.
And Ms.
Right.
Bridgewater?
Yes,
That,
ma'am.
that was going to be with mom taking him in, but that has changed now. So we're going back to Mr. Thompson.
Yes, so if may I say something about that just real quick? So, and that's the reason why. So Gary was with me before. And so when I tried to get him, I went down there to get him, but I wasn't on the order. But then I remembered the county took 1.5 year. I brought him home before, and they took 1.5 year to get him from me. And emotionally, I'm unable to support Gary. I would support him out of the home, which I have been doing. You know, go and see him, cut his hair, so forth, give him snacks and so forth, and make sure he's okay. But at home, emotionally, you know, I work at home with 7 days a week with children, at least 7 of them, and it's just eloping all the time, and it's just so stressful for me, you know, and I can't keep him safe here from if he's running away and getting hit. He broke his leg at the train station, and so that's why he's with the agency. But they're just pulling their legs. I mean, I don't know what's going on.
It sounds like we've got a resolution. Is that right?
I don't think so, because when I spoke to the worker today, she was like, well, Miss White.
Hold on, Miss White.
Okay.
Miss Allen, was that the case that we're talking about? I don't want to confuse myself here.
I'm going to send this to you all, you and Mr. McLean and Mrs. Bridgewater.
Okay.
The consent bond I just forwarded. It just adds his mother as a co-signer in addition to Melvin Thompson. And to stay away from 2729 Benjamin E. Mays.
I was under the impression we were having difficulty in finding him someplace to go.
Right. That's what they're saying. They're saying that they have the home, but not the number. And
So
the
it
number
sounds
supposed
like
to be
what's
coming from the
happening
region.
is, yes, he's in transit. People are trying to figure out where he can go. And mom is saying he can't come home to her. But she can sign him out.
But where's he gonna go?
I don't know that.
Where's he gonna go?
Let's ask Mr. McLean. I think what he told us is it's just pending. We got to figure it out. Maybe they'll have more information on the 24th.
Yeah, I can't sign him out and put him on the street. He's
We're not
not
asking you to do
cognitive.
that. We're not.
No.
Okay.
I would not.
I can't do that. I can't do that to him.
Okay. I think I'd feel more comfortable because I have no, to be quite honest, present recollection of this. So I think it would be best if he is heard on Thursday, and whoever the judge is on Thursday has the opportunity to have a full hearing on this to make sure that we're doing right by Mr. White and takes into account what Ms. White is saying. Okay.
Yes.
Okay.
All right,
Thank you, Your Honor.
Yes, so again, we will hear this, or this will be heard on Thursday at the SAP calendar. That's at 9 o'clock. And you'll get, if you haven't already, Ms. White, that information to be present, okay?
Yes, and I was asking if she had received it because I just want to make sure that they have my information.
Yes, ma'am. I am showing your well, it's for everyone to see here. You put your phone number on here and it's w.amoi@yahoo.com.
Yes, ma'am.
Yes, ma'am, we have it.
Okay, thank you.
You're welcome.
You have a good rest of your day, Miss White. Thank you.
Thank you. Bye-bye.
All right. Bye-bye now. Mr. McLean, if you will go into the breakout room now with courtroom 1 and Madam Interpreter, please.
Thank you.
Okay. We'll complete the calendar when they return. Okay, let's see, is courtroom, one, who would you like to start with?
Um, number 12. No, yeah, number 12.
Well,
Yeah, Montez.
all right,
Oh, I'm sorry, I'm sorry, yes. Okay.
okay, good afternoon, Mr. Adolfo Montez. I'm Judge Eric Morrow. You have been charged in case 25 CR 002094G with theft by taking and driving without a valid license.
Buenas tardes, señor Adolfo Montes. Siéntese bien. Mi nombre es el juez Eric Morrow y usted está siendo acusado por robo por apropiación y manejar sin licencia de conducir válida. El número de caso es el 25 CR 002094G.
Your history, Mr. Howard?
Le preguntan a la fiscalía si es que tiene historial.
Doubtful, 9 total. Has an open case out of municipal court for driving without a valid license.
Quien le indica al juez que tiene 9 casos en total y tiene un cargo abierto por manejar sin licencia de conducir válida.
Open case out of Brookhaven for DUI, driving without a valid license.
Tiene un caso de manejar bajo la influencia de alcohol en Brookhaven y manejar sin licencia de conducir.
Open case out of City of Atlanta, driving without a valid license.
Tiene otro caso abierto en la ciudad de Atlanta por manejar sin licencia de conducir válida.
2020, driving without a valid license conviction.
En el 2020, por manejar sin licencia de conducir.
2018 and 2016 as well.
Y en el 2018 y en el 2016 también.
Wanted out of Chambly.
Y tiene una orden de que se presente en Chambly.
Thank you. Ms. Harrison?
Yes, Judge. Okay, this incident occurred on April 21st, 2025. The incident location is 2525 Piedmont Road, Northeast Atlanta. It's a Home Depot store.
Y preguntan a la fiscalía los antecedentes de este caso. Esto dice ella que este caso ocurrió el 21 de abril del 2025. La dirección es del 2525 en la calle de Piedmont. Es un Home Depot.
Officers were on patrol in the area of Piedmont Road and observed a suspicious vehicle in front of the Home Depot store during the time the store was closed.
Los agentes de policía estaban patrullando el área de la calle de Piedmont y observaron el vehículo de estas personas estacionados en el Home Depot durante las horas que el Home Depot estaba cerrado.
Officers made a U-turn and approached the front of the store and the rear of the vehicle.
Los agentes de policía curvaron, hicieron una vuelta en U y se pararon detrás de el vehículo del acusado.
They observed a Hispanic male approach the front store and retrieve a large plant and place it in the rear of the black Toyota Camry with Georgia plates.
Ellos observaron un hombre hispano que estaba agarrando una planta y poniéndola en la parte de atrás de la camioneta.
The male approached for a second time in front of the store and retrieved a second plant and placed it in the rear of the Toyota Camry.
De ahí el señor fue a la parte de la tienda, a la puerta de la tienda nuevamente y agarró una segunda planta y le puso en la parte de atrás del Toyota Camry.
Officers conducted a stop in front of 2525 Piedmont Road.
Y los agentes de policía obviamente lo pararon ahí en el frente del 2525 Piedmont Road.
Identified the property in the car and identified The driver and the passenger. The driver was identified as the defendant and did not possess a valid driver's license.
Identificaron entonces al pasajero y al conductor y el conductor no tenía una licencia de conducir válida del estado.
The items taken totaled approximately $160.
Las cosas que fueron tomadas, robadas, tienen un total de aproximadamente $160.
In light of the defendant's prior arrest and convictions for driving without a license and a DUI, and in light of the fact of him being wanted, the state's recommendation is $1,000 signature bond, stay away from the incident location, and no alcohol, drugs, or weapons while on bond.
Dados los otros casos abiertos que tiene pendientes, la Fiscalía está ofreciendo un bono con firma de $1,000 y una orden de no puede conducir, no puede usar bebidas alcohólicas, ni drogas, ni poseer ningún arma, mientras este caso esté abierto y usted esté fuera bajo fianza.
Ms. Harrison, just so I'm clear, the state's requesting a signature bond?
Oh, I thought I said $1,000 surety bond. I'm sorry. I don't know what. If it came out signature, that was a mistake.
I thought I heard you wrong. Okay, thank you.
Ok, no fue un error. Lo que ella está pidiendo es un bono de fianza de $1,000 asegurados, no bajo firma.
All right. Who's this? Your case, Ms. McLeod?
No,
Whose
Your
case is
Honor.
this?
I think this
Okay.
is Mr. McLean's case.
Okay.
I think I represent Aiden.
It is.
Okay. All right. Yes, Mr. McLean.
Yes, Your Honor. We were thinking on ourselves, but at any rate, Your Honor, let me say this. He's 36 years old. He has a stable address on Peachtree Hill Avenue, a certain apartment number, a certain phone number. He does have the Chamblee hold. He knows how to get to the he's going to be taken to the Chamblee hold if they pick him up. And he also knows how to get to the misdemeanor clerk's office on the first floor of 160 Prior.
Do you want Madam Interpreter to interpret this, Mr. McLean? If so, you might want to slow down a bit for her.
These are words I've already said to him, but I'm sorry, you're right.
Esta persona, I'll be brief, Mr. McLean, and I do take notes. Esta persona, el señor Adolfo, tiene 36 años de edad. Tenemos una dirección válida de él en la calle Peachtree Hill y también tiene un reclamo donde tiene que regresar a la corte de Chamblee si es que la policía viene a recogerlo.
So, Your Honor, if we ask for a signature bond, if the court were to grant that, that would cause the release to Chamblee, and he knows how to make our court.
Entonces, si es que el juez podría darle un bono de fianza con la firma únicamente, entonces eso permitiría que la policía de Chamblee lo recoja, se lo lleve allá y él sabe cómo regresar a nuestro tribunal en Fulton para este caso.
The route between his apartment and his place of work, which is a restaurant at Peachtree and 8th, is a straight shot down Peachtree on the bus or by MARTA.
Del departamento donde él vive hasta el trabajo de él en el restaurante donde trabaja, hay un bus y es un bus que va directo, que pasa por la calle Peachtree.
There's no reason for him to be driving a car for that journey.
No hay razón para la cual él esté manejando un carro.
Okay, for each charge will be a $500 good bond, makes for a total of $1,000 good bond. Stay away from the Home Depot, the incident location, and no drugs, alcohol, weapons while out on bond.
Ok, y el fallo del juez es el siguiente. La fianza va a ser de $500 por cada acusación, un total de $1,000 con un bono asegurado, no con firma, sino asegurado. Una orden judicial de que no se acerque a la ubicación de Home Depot. en el 2525 Piedmont Road. Y una orden judicial de mientras está bajo fianza, no puede manejar, no puede usar bebidas alcohólicas, drogas, no puede poseer ningún arma hasta que no se cierre este caso.
Good luck to you, sir.
Buena suerte, señor. Ahora si el tío se pone en la otra silla, por favor.
Okay. Good afternoon, Mr. Adrian Montez. You have been charged in case 25 CR 002096H with theft by taking.
Señor Adrián Montes, buenas tardes. Este es el caso 25CR002096H y usted ha sido acusado de robo por apropiación.
Is there a history, Mr. Howard?
Second, 2018 DUI. Booking said he's homeless.
I'm sorry, Mr. Howard, after the 2018 DUI, I missed what you said after that. Can you repeat that?
Booking sheet stated he was homeless.
Got it. Entonces pide los antecedentes del juez y le indican que tiene una acusación del 2018, un caso de manejar bajo la influencia de alcohol y que la hoja de donde le recibieron a usted indica que no tiene casa, que no tiene casa donde vivir.
Same facts, Ms. Harrison?
Yes, sir, with the exception that the passenger and person taking the items from the front of the Home Depot was identified as the defendant.
Y tiene el mismo historial por la fiscalía y que usted, el acusado, fue identificado como el pasajero en el vehículo que estaba tomando o robando las otras cosas del Home Depot.
State's recommendation?
The state's recommendation is a signature bond, a stay away from the incident location, and we're requesting no alcohol, drugs, or weapons. And I'm going to repeat myself. The state is recommending a signature bond through pretrial services.
Y la recomendación que tiene la fiscalía es un bono bajo firma únicamente y que durante el tiempo que esté fuera por fianza no puede manejar, no puede beber bebidas alcohólicas, no puede usar ninguna droga o estupefaciente y no puede poseer ningún arma.
Ms. McLeod, if it's okay with you, it will be a $2,000 signature bond through the jail, stay away from the Home Depot, and no drugs, alcohol, weapons while out on bond. Does that suit you?
It suits me, Your Honor. I was going to ask that it be through the jail.
Con la abogada defensora, lo que acuerda el juez y lo que falla el juez es un bono de fianza con firma únicamente por $2,000 y puede salir, pero hasta que regrese a su caso a la corte está bajo fianza y no puede manejar, no puede usar ninguna bebida alcohólica, droga, estupefaciente o poseer ningún arma.
Good luck to you, Mr. Montez.
Buena suerte, señor Montes.
Thank you.
Johnny, you said that was a 1,000 signature bond?
It's a $2,000 signature bond through the jail.
Una pregunta.
Okay.
Okay. Your
Let's see. Say it again.
Perdón, ¿qué?
Salir hoy.
Would I be let out today?
As soon as the jail can process you out.
En cuanto que la cárcel pueda procesar su salida.
Okay. Muchas gracias.
All right.
Thank you.
All right, I believe that completes the 2 o'clock calendar. If nothing else, you all have a good rest of your day. Thank you, Madam Interpreter. We appreciate your help this afternoon.
Thank you, Your Honor. You have a good afternoon.
Thank
Thank
you.
you.
Honor.
All right, I'll see you next time. Have a good evening, everyone.
You too. Thanks, everyone.
You're welcome.